Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on today's program. Today's program is entitled the Ethics and Law Series, and today we're focused on the limited topic of unprofessional chiropractic conduct. So let's begin our program today. And let's begin by first talking a little bit about the Board of Chiropractic Examiners. Now, the Board of Chiropractic Examiners is a governmental body, the purpose of which is to protect the public. So I've copied for you here the board's mission statement exactly as it's described in the Chiropractic Initiative Act. And the Chiropractic Initiative Act has been around since 1922, and Section 10A clearly states the board's vision and the board's mission statement. And it says, and I'm just going to read this, it says that the board may, by rule or regulation, adopt, amend, or repeal rules of professional conduct appropriate to the establishment and maintenance of a high standard of professional service and the protection of the public. So it's the Board of Chiropractic Examiners that defines what qualifies as both professional conduct and therefore what also qualifies as unprofessional conduct. And the purpose of establishing these codes of conduct is, as the board states, to establish a high standard of professional chiropractic service and to protect consumers of chiropractic services in the state of California from those chiropractors that may fall below the standards and may jeopardize the health, safety, and welfare of the public. So that is the board's mission, and it is specifically to protect the public. And I know for some doctors this comes as new information, and I myself wasn't exactly clear coming out of chiropractic school what was the purpose of the Board of Chiropractic Examiners. I thought the Board of Chiropractic Examiners was there to help me as a chiropractor and to provide information and guidance for me as a chiropractor, and that's not the case at all. However, if you do not follow the board's rules and regulations, they will be in contact with you very quickly to discipline you. So it's important that you take a proactive approach to knowing the board's mission and how the board goes about its procedures and how the board goes about disciplining doctors that fall below their established and published standards of professional conduct. Now, specifically in Section 317 of the Board's Rules and Regulations, the Board states that they shall take action against any holder of a license who is guilty of unprofessional conduct, which has been brought to its attention. And let me just stop right there. You may be guilty, and you may be involved with unprofessional conduct, and you may get away with that forever. But it's when that attention, or when that conduct, that unprofessional conduct, is brought to the board's attention, usually by way of a consumer complaint, meaning one of your patients issues a complaint, then the board shall take action. And that's pretty much how all these boards work in the state of California. They have no knowledge of any wrongdoing that you may be involved with until such time as they receive a complaint, and then of course they jump to action. And we'll talk about some of the actions that the board can take as we go through the program. So let's begin with Section 317, which defines what the board considers to be unprofessional conduct. And the board lists no fewer than 24 examples of unprofessional conduct, and they list these in subsections A all the way through subsection X. So there's 26 letters in the alphabet, and A through X is the first 24 letters, so there's at least 24 examples of what the board qualifies or considers to be unprofessional conduct. And many of these categories have cross relations and cross permutations and cross interactions, and so the number of possible instances of infractions of these regulations are really arithmetically and exponentially increased. And let's go through these one at a time, and then what we'll do is in the second hour of this program, we're going to pick 3 of the most common violations that chiropractors are involved with, and we're going to dissect those down into greater detail and look at those with some more clarity. And the philosophy of this program is based upon a new movement by the Board of Chiropractic Examiners to statistically define and categorize the numbers of violations that chiropractors are involved with, and then to produce continuing education programs designed to educate and train doctors on how to safely operate their chiropractic practices and minimize any harm to the public. So this is a movement that the board is involved with and beginning to ramp up, at least at the time of this recording, which is in mid-2014. So the board states in Regulation 317 that unprofessional conduct includes, but is not limited to, the following. And we're just going to go through these subsections A through X fairly quickly. It includes Section A, gross negligence. Section B, it includes repeated negligent acts. And Section C includes incompetence. So let's define each one of these terms here so that we're clear on what it is that the board is talking about. Now, according to Webster's dictionary, negligence refers to the failure to take the care that a responsible person usually takes. It's a lack of normal care or attention. Also, negligence can be defined as the quality or state of being negligent, meaning failing to take proper or normal care of something or someone. And of course, as chiropractors, we're charged with taking care of human beings. We call those our patients. So a negligent chiropractor is a doctor who fails to take proper care that another responsible chiropractor would consider to be normal and proper care. And it's interesting because we have to define negligence in terms of what would a responsible chiropractor do. In other words, we're not talking here about what would an average person do. We're talking about what would a responsible and average chiropractor do. And that's the measure and that's the standard against which claims of negligence will be measured. Now, gross negligence is something entirely different, and you'll notice that the Board of Chiropractic Examiners puts gross negligence at the very top of their list of violations. So gross negligence is slightly worse even than negligence, in that gross negligence involves a motive of intent. So gross negligence can be defined as carelessness, which is in reckless disregard for the safety of or lives of others. And let me just pause right there. Gross negligence is carelessness, the absence of care. The absence of care is careless. And so a doctor who's grossly negligent is really a doctor who doesn't care, and he acts in reckless disregard for the safety or lives of others. And that's closely related to being an antisocial personality. Antisocial is defined as having a pattern of disregard and violation of the rights of others. Well, here with negligence, we're having disregard for the safety or the lives of others. And gross negligence is so great that it appears to be a conscious violation of other people's rights to safety. It's more than simply inadvertence, but it's just shy of being intentionally evil. So, according to Merriam-Webster's dictionary, gross negligence involves willful intent and willful reckless disregard and conscious, planned, and willful violation of other people's rights. And this makes sense that the board would discipline these types of providers. In fact, we do not need these types of providers in our industry. These types of providers are dangerous and give us all a bad name. Now, I want to give you an example of gross negligence in a non-chiropractic setting, and then just want to together go through an exercise where we think of how this would manifest in the actual setting of the chiropractic treatment practice. So in a non-chiropractic setting, if a person has contracted with another person for the first person to take care of the other person's property in the absence of that other person, perhaps maybe on vacation or away or out of town for an extended period of time, then gross negligence is the failure to actively take the care one would of his or her own property. And we can sort of analogize that to the chiropractic practice by saying that gross negligence would be exemplified by failing to take care of our patients in a way that we would want our own selves cared for, or that we would want someone from our own family to be cared for. And gross negligence is quite punishable. In fact, if it's found by the trier of fact, meaning either a judge or a jury, to be bona fide, then it can result in an award of punitive damages on top of both general and specific damages. And so these would be strong allegations of gross negligence. Now, how could this manifest in a chiropractic practice? How could gross negligence, careless disregard, reckless disregard, conscious violation? Well, I would hope that examples of this would be difficult to describe, but you can probably imagine some egregious situations, perhaps involving hot packs, perhaps left on too long and consciously left on too long, ice packs placed on unprotected skin and causing frostbite and skin damages, other conscious and reckless acts such as overly forceful manipulations, that are clearly painful to the patient. And I want you to just think in your own mind about the course of your chiropractic practice and ask yourself the question, could an outside party, if they were to observe the treatment protocols and patterns that take place in the office on a daily basis, could an outside observer opine or suspect or consider that some of your procedures might be grossly negligent? I would hope not, but I encourage you to just think along the lines of a lay person or an objective outside observer and think how they could possibly conclude. Okay, so that's gross negligence. Now, incompetence is a little bit different. Incompetence is simply the lack of the ability to do something well, or the quality or state of not being competent. And I'm certain that if you've ever had chiropractic adjustments from other chiropractors, there may be times when you've had adjustments that you felt that were just not competent. And this sometimes happens when doctors are new at certain techniques that they've just learned, or they're just implementing some new procedures that they've been experimenting with. And there are other examples that I'm sure you could come up with wherein it's possible that a practitioner could be performing procedures that they're simply not quite yet mastered. something that they're not quite yet proficient in delivering, and that would qualify under the board's definition of incompetence. And so the board does discipline for bona fide instances where incompetence can be established. Now, subsection D of section 317 says that the board can take action for unprofessional conduct when the administration of treatment or the use of diagnostic procedures are clearly excessive, as determined by the customary practice and the standards of local community of licensees. And this is an interesting section, and we're going to discuss this more here in a few minutes, but I highlight for you, those of you that have the PowerPoint presentation, I highlight for you here what the board describes. And what they describe is they describe standards of the local community of licensees. And this is the standard against which we as chiropractors are judged. We're judged against the local community of licensees. And an important point to note here is that as chiropractors, we all have different training and different interests and different credentials and different pursuits and different treatment modalities. And once we get out of chiropractic school, we seem to go in all these divergent different pathways of interest and practice. And some of these niches in chiropractic are involved with unique treatment methods, unique diagnostic methods, different treatment procedures, and those can create unique standards that do not apply to the local community of licensees. For example, if you consider a chiropractic technique such as active release technique, or Logan basic technique, or taping techniques, or any treatment modality that is unique to some training that you have learned, that might not qualify and that might not stack up to scrutiny by the local community of licensees. For example, I'll give another example. Some doctors are board certified in chiropractic neurology, and as a result of the training that they've learned in chiropractic neurology, they perform treatment techniques and diagnostic techniques that are designed to restore certain functions of parts of the nervous system that other chiropractors in the local community have not learned, have not practiced, and do not implement those procedures. And so some of those doctors, if they were called upon to comment on the competence or the presence of negligence of these treatment modalities, might opine that those treatment practices are excessive or even unnecessary, at least from their viewpoint. So I mention this to you to keep in mind that in all practices, you are going to be compared against the local community of licensees. And so you want to think about what is the local community of your licensees, meaning your colleagues, your chiropractors. What are they involved with, and what types of treatment modalities are they involved with, and how do your treatment and diagnostic procedures stack up in relation to the local community. And we'll talk a little bit more about this specifically in a few minutes. Subsection E says, any conduct which has endangered or is likely to endanger the health, welfare, or safety of the public. Subsection F is the administering to oneself of any controlled substance or the use of any dangerous drug or of alcoholic beverages to the extent or in a manner as to be dangerous or injurious to oneself or to any other person or to the public, or to the extent that the use impairs the ability of the person to conduct with safety to the public the practice authorized by the license. And we're going to dissect this one in great length here in just a minute. Subsection G says that the board can take action in any situation where the practitioner has been convicted of a crime which is substantially related to the qualifications, functions, or duties of a chiropractor. And it's interesting because the Board of Chiropractic Examiners requires that we divulge and disclose any criminal convictions annually when we renew our chiropractic license. And I myself just recently renewed my chiropractic license, and I have right here in front of me my renewal application, or I should say a copy of my renewal application. And I want to read for you right from the renewal application. And this is right on the face page, page number 1 of the renewal application. About 2/3 of the way down the page, there's a paragraph heading entitled Criminal Convictions, : and it says, and I'm just going to read this off the form, it says, if you have been convicted or pled no contest within the past renewal period to any violation of local, state, or federal law, you must provide a detailed explanation of the incident with your renewal. Note: traffic infractions that resulted in fines of less than $500 that did not involve alcohol, dangerous drugs, or controlled substances need not be disclosed. So the board is telling us here that if you've been involved in any traffic violation greater than $500, or if you've been involved in any traffic violations that involve alcohol, drugs, or controlled substances, you must disclose that on your renewal application. Further, if you've been convicted or even pled no contest to any violation of local laws, state laws, or federal laws, you must disclose it on your renewal application. Now, my interpretation of this, and I've shuddered every time I've read this over the past 27 years as I've renewed my chiropractic license, my interpretation of this is that the board is interested in keeping all licensed chiropractors in the state of California what I'm going to refer to as good boys and good girls. If you've been involved in any criminal convictions, they're going to take action against your chiropractic license. If you're involved in expensive traffic violations, they're going to take action against your chiropractic license. If you've been involved with traffic infractions that involve alcohol, such as a DUI, they're going to take actions against your license. The board wants us to be good boys and good girls and people that can be responsibly expected to take good care of the public. Otherwise, they state in their regulations that they can take action against us. Subsection H, let's continue along this same line. The board can take action if they learn that you've been convicted of any offense, whether felony or misdemeanor. And before I move on to the remainder of this section, I want to just define for you the differences between a felony and a misdemeanor. Now, a misdemeanor is a crime that is not very serious. It's a crime that's less serious than a felony, and the most serious punishment for a misdemeanor is usually no more than detention in a county jail. On the other hand, a felony is a more serious crime. Murder qualifies as a felony. Rape qualifies as a felony. And the Law Dictionary describes felony as a crime that is sufficiently serious to be punishable by death or a term in state or federal prison, as distinguished from a misdemeanor, which is only punishable by confinement to county or local jail and or a fine. And a felony is a crime carrying a minimum term of 1 year or more in a state prison, since a year or less can be served in a county jail. However, a sentence upon conviction for a felony may sometimes be less than 1 year at the discretion of the judge and within limits to which are set by statute. So felonies are what we can describe as high crimes. Well, our Board of Chiropractic Examiners clearly states that you don't have to be convicted of a high crime. Even a conviction of a misdemeanor is grounds sufficient for the board to take action. So let's continue with subsection H now that we know what felonies and misdemeanors are. So the board states that the conviction of any offense, whether felony or misdemeanor, involving moral turpitude, dishonesty, physical violence, or corruption. Now, moral turpitude is defined as a very evil quality or a very evil way of behaving. Turpitude involves inherent baseness or the performance of vile acts. Now, some synonyms with turpitude to help you understand what turpitude is. Synonyms would include abjection, corruptness, debasement, decadence, pervertedness, or degradation. And the board takes serious attention to convictions that involve moral turpitude, convictions that involve dishonesty, convictions that involve physical violence and or corruption. And it's interesting that even physical violence, such as fighting, is grounds for the board to take action against your license. Now, if you're a chiropractor, I'm certain that on a daily basis you don't get involved in fights in your chiropractic practice. But aren't there situations out in the public that sometimes you've felt perhaps like you were going to get involved in a fight, or maybe that you wanted to fight, or I don't know, that you thought that perhaps a fight could break out? In other words, fighting is common in the general public, but the board is clear that they do not want chiropractors involved with physical violence, whether in the chiropractic office or even outside the chiropractic office. And if you're convicted of any of these, the board may inquire into the circumstances surrounding the commission of the crime in order to fix the degree of discipline, or to determine if such a conviction was of an offense involving either moral turpitude, dishonesty, physical violence, or corruption. And the degree of discipline will correspond to the board's interpretation of how vile the act was and how base the behavior was. Now, what's interesting about this particular subsection is that a plea or a verdict of guilty and even a plea of no contest is deemed to be a conviction within the meaning of the board's disciplinary provisions. So I'm not a lawyer, but I interpret this to mean that the board issues its harshest penalties even in cases where you plead no contest. They consider that to be a conviction of guilty. And under those situations, the board can order the license to be suspended or revoked, or may decline to even issue a license for those chiropractors who are seeking their first licensure with the Board of Chiropractic Examiners. So the board is very, very serious that we maintain absolute propriety both in our chiropractic practice and then also out in the public. And I want you to give second thought to this. Not just think of this every 12 months when you fill out your chiropractic application for renewal, But think about this on a frequent basis and ask yourself, am I acting and behaving in any way that the board could consider to be a violation of their rules and regulations? Okay, so with that thought, let's continue. Subsection I states that the board can take action when they find that there's been a conviction of more than one misdemeanor or any felony involving the use, consumption, or self-administration of any dangerous drug or any combination, of any dangerous drug or alcoholic beverage or any combination of those substances. And then subsection J, the violation of any of the provisions of law regarding the dispensing or administration of narcotics, dangerous drugs, or controlled substances. And we're going to define here in just a few minutes what qualifies as dangerous drugs and what qualifies as as controlled substances. And we're going to get into this particular issue of the use of drugs, alcohol, and controlled substances by chiropractors. So let's just hold on that here for now. Subsection K, the commission of any act involving moral turpitude, dishonesty, or corruption, whether the act is committed in the course of the individual's activities as a license holder or otherwise. Or otherwise means out in the general public, out at a party, on the weekend, on the boat, at the lake, on the hockey rink, in the gym. Any commission, it doesn't say the conviction, it says the commission of any act involving moral turpitude, dishonesty, or corruption. The board wants us to be conservative, it wants us to be responsible, it wants us to be involved in only the highest level of moral behavior. Subsection L, knowingly making or signing any certificate or other document relating to the practice of chiropractic, which falsely represents the existence or the non-existence of a state of facts. That has to deal with the documents that you sign. Subsection M involves violating or attempting to violate, either directly or indirectly, or assisting in or abetting in the violation of or conspiring to violate any provision or term of the act or the regulation adopted by the board thereunder. And there is a catch-all phrase that basically includes any possible additional violation that the board considers to be contrary to the Chiropractic Initiative Act. And this is a very broad, sweeping section. Okay, a couple more sections. Subsection N involves the making or giving any false statement or information in connection with the application for issuance of a license. Subsection O is impersonating an applicant or acting as a proxy for an applicant in any examination required by the board for the issuance of a license or certificate. Subsection P is the use of advertising related to chiropractic, which violates Section 17500 of the Business and Professions Code. And Section 17500 of the Business and Profession Code basically applies to many professions, not just chiropractic. But it involves advertising for stuff that really isn't true, especially for advertising for services that you really don't deliver, and advertising for things which the consumer has an interest in that you then fail to truthfully deliver. And you might want to look up Section 17500 to be familiar with that code. Subsection Q says the participation in any act of fraud or misrepresentation, and I presume that means both within and outside the practice of chiropractic. Subsection R says, except as may be required by law, the unauthorized disclosure of any information about a patient revealed or discovered during the course of examination or treatment. And what could some of those things be? What could some information about a patient be revealed or discovered during an examination or a treatment that your unauthorized disclosure of could harm that patient? What could some of those things be? Well, I'll just let you think about that for a minute, but of course it could be anything physically about the patient, anything about the patient's personal life, any confidential information that the patient has shared with you in the confines of the chiropractic treatment room. That is confidential information not to be disclosed, and the board punishes when they discover that you have unauthorized or without authorization you have disclosed sensitive information. Subsection S involves the employment or use of persons known as cappers or steerers to obtain business. Subsection T involves the offering, delivering, receiving, or accepting of any rebate, refund, commission, preference, patronage, dividend, discount, or any other consideration as compensation or inducement for referring patients to any person. And we'll talk about this one a little bit more as we get towards the end of this program. A couple more sections. The board punishes for participation in information or referral bureaus which do not comply with sections 317.1 of the regulations. Subsection V is entering into an agreement to waive co-payments or any deductible amounts of any insurance policy by forgiving any or all of the patient's obligation for payment. And then finally, subsections W and X. W is referred to as the failure to refer. And let me just read this section to you. Not referring a patient to a physician and surgeon or other licensed healthcare provider who can provide the appropriate management of a patient's physical or mental condition, disease, or injury within his or her scope of practice, if, in the course of a diagnostic evaluation, a chiropractor detects an abnormality that indicates the patient has a physical or mental condition, disease, or injury that is not subject to appropriate management by chiropractic methods and techniques. This subsection shall not apply where the patient states that he or she is already under the care of such other physician and surgeon or other licensed healthcare provider who is providing the appropriate management for that physical or mental condition, disease, or injury within his or her scope of practice. So that's the failure to refer regulation. And then finally, subsection X is the offer, the advertisement, or the substitution of a spinal manipulation in place of vaccination. Okay, so those are chiropractic regulations A through X. Let's now break out some of these more common violations and examine them in more detail. Specifically, the substance abuse violation, the conflict of interest violation, and also the violations that involve excessive treatment by chiropractors. So doctors, I hope this has been helpful for you. This is a brief program. It's not the typical type of program that I'm usually involved with. My main interest is in physical examination and anatomy, and you'll see that by looking at the courses that are on my website. However, I took this program on and created the Ethics and Law series to provide some real training and some real discussion for you and for me, and to keep fresh forever in our minds situations that could potentially jeopardize the exalted position that the public bestows upon us as doctors. The doctor title and the doctor position, the doctor stature is legendary in the eyes of the public. And we need to acknowledge that and constantly keep that at the forefront of our mind and behave responsibly and always behave in the best interests of our patients. And so with that in mind, I created this series on ethics and law for both of us, as reminders to both of us to always be on the top of our game. So that concludes this course. I hope you learned some things from this course. Included with this course is a 5-question course examination. When you're done, please fax or email that back to me. I've included the email address here for you. For those of you that have the PowerPoint presentation, also have the fax number here for you as well. And just as soon as I get that course examination, I'll issue your certificate of completion immediately. And I want to remind you to remember to visit our website, which is easychiropracticCEU.com, for programs and products designed to help you succeed as a chiropractor. For now, this is Dr. Perry Carpenter. I'm looking forward to being with you on future programs. And for now, I'm wishing you best of success in your career as a chiropractor. Again, thank you very much.